Good afternoon. Thank you to the reporters who attended today. I'd like to introduce my team, Greg Yates, John Manley, Ariel Romero, and our client, Akeila Jefferson. We are here today to discuss yesterday's landmark $828 million settlement of child sexual abuse claims and the controversy surrounding the earlier $4 billion settlement. Manley, Stewart, and Finaldi has represented victims of child sexual abuse for the past 30 years. We were lead counsel in the Larry Nassar case, the physician cases at USC and UCLA, and hundreds of cases involving the Catholic Church and schools across our nation. Together with Greg Yates, we were the first to file lawsuits 3 years ago on behalf of 70 women who were incarcerated and molested as little girls. We served as liaison counsel to the court in all of the cases against the Los Angeles County Probation Department, and we currently represent over 150 women who are abused. Together with our clients, we expose the systemic abuse of children in the custody of the county during the past 3 decades. Our clients, as a result of this settlement, received 3 times the average amount the county agreed to pay to plaintiffs in the $4 billion settlement, and there is a very good reason for it. We deposed dozens of current and former probation department officials, those in charge of the camps where children were raped and abused. The county deposed no one. We exposed the fact that the county knew about the sexual abuse of our clients and did nothing. There were reports documented that children like Akeila were courageous enough to report their abuse to county officials. The county officials merely passed the trash, moved the abuser, and did nothing. It became clear that no one in the county gave a damn about the children entrusted to them, and that's why our case settled. Recently, the LA Times reported that other firms using cappers and unethical marketing have exploited the system for their own gain. Mark my words, this is plain fraud. But months, if not years, before the LA Times exposed this story of potentially false claims being approved and paid out by the county, we, our firm, called out these claims openly and on numerous occasions in court, not once, not twice. When the Board of Supervisors were confronted with this scandal publicly following the bombshell story by Rebecca Ellis of the LA Times, their response was to attack the victims and attack the victims' right to justice under AB 218, which opened the window for older claims to be filed. But why did the county do nothing when we informed them of this fraud years ago? Why did the county do no diligence to investigate those claims? Why did the county not take one deposition or interview one plaintiff? This isn't normal. We've never seen it. This is fraud and corruption at the highest level. And it's a stain on our profession, on those like myself, a former sex crimes prosecutor for the county, who has devoted my life's work to representing true victims of crime, the most heinous crimes. We are talking about young little girls getting raped by county officials and law enforcement. The public, our clients, the victims of these heinous crimes deserve a full investigation by state and federal law enforcement. We are so proud of our clients who are courageous enough to stand up, to speak out against the county, and to fight the good fight that we have over the past 3 years. It is my honor and privilege to introduce Akeila Jefferson, who has gone public with her story on behalf of herself and so many other survivors.
Hi, my name is Akeila Jefferson. I live in San Bernardino County. I'm currently working as a gang interventionist and a sexual abuse advocate at Advocates for Peace and Urban Unity in South Central Los Angeles. I was one of the first survivors in Camp Scott to come forward and hire an attorney. A friend of mine who was also in Camp Scott told me that my abuser, Thomas Jackson, was still working there and abusing children. I felt that I needed to come forward and do something about it. I had a friend who previously worked with Mr. Yates, and she introduced me to him, and I'm greatly appreciative that she did. What happened to me as a child in the custody of LA County Probation system was a nightmare. Since coming forward, I have learned what happened to me had happened to so many other young girls just like me. My parents were two teenage parents at the time of having me, so they left me to be raised by my grandmother. I began skipping school, stealing, and things like that, and I ended up in Camp Scott. Camp Scott was supposed to be a boot camp meant to help troubled teens through military-style discipline, education, and tough love. Camp Scott was none of that. Instead, I was sexually abused at the hands of a guard, Thomas Jackson, for years. I have since learned that it was 30 more girls just like me that was abused by him as well. Since coming forward, I have testified before the California legislation twice and was a subject to an ABC News documentary that exposed the rape and sexual assault upon vulnerable children and a cover-up of those in charge. Yesterday's settlement of our cases proves that there were real victims, real trauma, and a real need for the government to step up and to protect the children of Los Angeles.
I'd like to now introduce our colleague and attorney, Gregory Yates.
Okay. All right. Good afternoon. I'm Gregory Yates, and I'd like to point out that I have the privilege of being able to address this issue because Akeila contacted me some time ago because she was referred to me by a previous client that I'd represented about 20 years before that, who was a victim of rape by a LA police officer. After doing my due diligence on Akeila's case, I realized that there was probably, this was just an underbelly of what was going on or went on. So as I started to investigate her case and contact some of the witnesses that she had to her abuse, I found that some of them who were also victims of her abuser, probation officer that abused her, also wanted to proceed with an action. So I started to accumulate quite a few cases, and I decided to partner up with John Manley's firm, worked with them in the past, at the best, and we went forward. In doing so, what Akeila did was open the floodgates and gave a voice to literally thousands of victims of childhood sex abuse to pursue justice and restitution. Akeila was, in fact, the first to step forward heroically and bravely to publicly break her anonymity back in 2022. I remember well when Akeila contacted me, and it never crossed my mind that I had an idea something was going on. Where there's smoke, there's fire, but I had no idea the fire that she would have lit by pursuing her case to the extent that literally thousands of young boys and girls were sexually molested at probation camps throughout Los Angeles County. What came to light was an explosion of abuse that was covered up by LA County systemically, as my co-counsel indicated. None of us as taxpayers particularly relish the idea of footing the bill for what happened in these probation camps, but let's not lose sight of what really happened here, and it's clear that it happened. A cabal of probation officers at the LA County probation facilities and camps laid in wait for each new crop to come in of minors between the age of 12 and 17. And when they arrived, traditionally, the probation officer with the most seniority would have his pick of the batch to make his personal sex slave. And how much more craven and despicable and perverted can you get? The evidence clearly showed that the County of Los Angeles was aware of this and swept it under the table, turned a blind eye. The result was that even more rampant sexual abuse took place over a period of almost 3 or 4 decades in the county facilities. These young individuals were there to be rehabilitated, not made sex slaves. The evidence showed, as I said, that this continued for almost 4 decades, and there was absolutely no meaningful action taken by the county to prevent it. Courtney Tom, a co-counsel of the Manley firm, as she unduly humbly said, was involved in litigating this case. She alone, by herself, took literally dozens of depositions, conducted extensive discovery, and filed numerous motions which revealed clearly that there was a pattern and practice within LA County of condoning sexual abuse of minor children in their probation camps. We must be able to trust our law enforcement with our children. They have a duty to protect them. This is particularly true and important when the minors are there to be rehabilitated, to prepare them to hopefully become productive members of society. This abuse of authority is beyond all boundaries of human decency. Childhood sex abuse is a self-concealing injury that's passed on from generation to generation. ABA 218 was an enlightened, evolved bill because experts had conclusively found that victims of childhood sex abuse either repress, suppress, never remember, or when they do remember, do not understand the significance of how that's impacted their life. Thank you.
Good morning. My name is John Manley. I'm the principal of firm. And actually, I wasn't going to speak today, but I watched with dismay, horror, and disgust at the Board of Supervisors hearing yesterday. Let's be clear. The reason we're here isn't because the legislature allowed child rape victims, when they passed AB 218, to have access to the courts for justice. The reason we're here is the 35-year failure of the county Board of Supervisors, past and present, the probation department, and the probation department's union to allow a cabal of raping and molesting probation officers to have access to girls. We didn't take any male cases. We decided to focus on the women at Camp Scott and other camps and facilities. What happened there was a horror. And I keep hearing politicians on both sides of the aisle in Washington and here, and in fact, I think I've seen some of the Board of Supervisors talk about Mr. Epstein, and we got to get the files on Mr. Epstein, and we got to get the files on Mr. Epstein. There were hundreds of Epsteins in the probation department. And they went wild at public expense. It was so bad, there was a federal monitor that's been appointed for years. The county today still is not in compliance with the prison rape reform statutes that Congress has passed. And the truth is, no one gives a shit. No one gives a shit. There's no investigation asked by the Board of Supervisors to investigate how this happened. No, they're going to pay $4 billion now. Actually, it's closer to $5 billion, and not have a single internal investigation by an outside law firm, an outside district attorney's office, state attorney general's office, or the U.S. attorney's office. Ask yourself why that is. Ask yourself how it is that they've learned about massive fraud by not one, massive alleged fraud by not one but two law firms involving thousands of claims. And they're just going to proceed with that settlement. You know, I've been doing this a long time, since 1997, and I've sued and represented thousands of survivors against some of the largest institutions in the world that care for children. I believe in my heart there is corruption here. I don't have access to the documents to prove it, but when an institution agrees to pay $4 billion and just says, we're good to go and we'll have somebody else investigate it, and don't look at it, this is going to happen again. And I got to be honest, the county council, not outside council, but county council in this case, should be fired. I raised the fraud issue repeatedly in letters in front of the court. And the court knew it. The judge raised it with them. And not only did they not do anything about it, they took the guardrails off. Under AB 218, you have to file certificates of merit. You have to get a psychologist to declare under penalty of perjury that this happened. The county waived it. So, you know, they're actually talking about, you know, attorneys that did this and attorneys that did that, and certainly that's legitimate, and the attorneys that did this should be investigated, and if they did it as accused, they should go to jail. But equally important is the idea that the county let it happen and why. That $4 billion settlement, in my opinion, reeks. And they did their clients no favors. The other thing that happened yesterday, as I heard county council talk about how it was important that they team up with Los Angeles Unified School District. I mean, that's like asking Epstein to team up with Harvey Weinstein in terms of institutions. I don't know of any school district in the country that has a worse record on child protection in terms of sexual abuse than LAUSD. There's something very wrong with county government in LA. There's something very wrong with LAUSD. This didn't happen because some sleazy attorney advertised for cases. This happened because they put kids in harm's way. I want to say one more thing. Our brave client, Akeila, standing next to us, will never meet the children she saved from this, but they exist, and in my opinion, by the thousands. And I hope people remember it just takes one person to come forward and raise their hand and say, this happened to me, and I'm not going to allow it to happen to another little girl. Thank you. I think you wrap it up for me.
Thank you again for all attending today. We've heard so many voices in regards to both settlements, whether it's the Board of Supervisors, County Council, the CEO, Chief Probation Officer yesterday, but the only voices that truly matter are those of the victims involved here. Akeila stands here on behalf of so many others. We represent over 150 women whose voice was finally heard yesterday. Thank you.